An Ohio professor is walking away $400,000 richer after winning a lawsuit against a university over pronouns. Yes, pronouns. So the legal battle started in 2018 after Shawnee State University reportedly punished Professor Nick Meriwether for not addressing a transgender student with their preferred gender pronouns. The professor argued that the university had violated his rights as this went against his Christian beliefs. Meriwether was assisted and represented by the Alliance Defending Freedom, who created this next video to help share his story. Take a look.
Is Dr. Nicholas Meriwether. For over 20 years, I've had the joy of serving as a philosophy professor at Shawnee State University in Portsmouth, Ohio. During that time, I focused my scholarship and teaching on the intersection of philosophy, ethics, religion, and political theory. When I began teaching my political philosophy class in the spring of 2018, I had no idea the first day's discussion would bring me to the U.S. Court of Appeals for the Sixth Circuit, but it did. On that day, a male student raised his hand, and I responded with a simple, "Yes, sir." I refer to my students as sir or ma'am or by a title, Mr. or Miss, for example, and their last name. The formality fosters an atmosphere of seriousness, mutual respect, and courtesy, and I've always referred to students based on their biological sex. After all, that is who they are. After class, the student approached me, identified himself as a woman, and insisted that I refer to him as such, using feminine terms. When I expressed reservations about his demands, the student became belligerent, got in my face, and began circling around me to intimidate me. Swearing at me, he promised to get me fired if I didn't instantly agree to his demands. Within days, I offered to accommodate him. I was willing to use any name he preferred, and I was also willing to simply drop sir, ma'am, and other sex-specific titles for him. I had hoped that university administrators would understand my position, even if some disagreed with it. At first, they agreed that I had struck the right balance. After all, I was willing to avoid using a pronoun that offended my student. So why would they force me to use a pronoun that offends my conscience? But that wasn't enough to satisfy the student, and the university soon reversed its position. Officials now insisted that I either use identity-based terms, including recently concocted pronouns like zir and z, for all students, or eliminate all sex-referencing terms from my vocabulary at all times.
Joining me now to discuss is criminal defense attorney and anchor at Law and Crime Network, Bob Bianchi. Bob, thank you so much for joining me. So, Bob, I bet universities all over the country were watching this case closely to see how it would end up, and it appears to be sending a strong message to universities.
You know, this has been going on for like 20 or 30 years. I go back to when I went to a Catholic law school, and they actually took the crucifix away from the door of the library because people were complaining about the religious overtones. And of course, a lot of us were kind of irate because the essence of why we were there was because it had a Catholic education. Whether you agree with that or not, they pandered to the students, the minority of students who had a problem with it. And here we are decades later now dealing with this. And we've talked about this before, Stephanie. It's interesting where these new ideas run into the religious freedoms and the religious opinions of other individuals who do not want to go along with the flavor of the day, if you will. So this professor, interestingly to me, really struck the appropriate quote unquote accommodation that we speak about under the law, where you try to reason and mediate between two differing opinions, his belief that was against his religious principles and the students wanting to be referred to in a sex opposite than their biological sex, and that wasn't good enough. And once again, the university, instead of standing up and supporting their professor, which they originally did, caved in to public pressure, and now they paid the price.
Yeah, as you pointed out, it appears that the professor did everything that he could to accommodate the student in a way that made sense to him, and yet still the university didn't back him up. In this type of case, I have a feeling that we've seen a lot of similar type battles, but I have a feeling we're going to see a lot more of these. Do you think universities will make new rules in their books that will basically say, like, if you want to work at this university, you're going to have to abide by our rules and, call the students whatever pronoun they want to be called?
Yeah, I think you could see that, and that would actually be fair game territory in terms of the legal. You may not agree with it if again from a personal point of view, but if the professors are going in there and accepting a condition of employment, then that is a little bit of a different issue because it's a contract issue. But on the other side of that, that's what we do as lawyers. We argue both sides in our brain. Is that contractual provision lawful if it's essentially discriminating against a group of people, let's say a faith-based group that simply just cannot do that because it's against their religious beliefs? So there would be an issue as to whether that contractual term can actually be enforced. So they're going to have to do a lot of fine-tuned lawyering here because there are serious constitutional issues here with regard to the First Amendment right to free speech and the freedom of religion, the freedom to express your religion versus referring to people by a certain name or a certain way, which I'm not sure is a constitutionally protected thing, at least at this point. So I think those who have the First Amendment right to freedom of religion and freedom of conscience have a better argument right now against being forced to do that.
Well, they were making a comparison that you can't force students to say the Pledge of Allegiance, if you will. So therefore, you can't force a teacher to call somebody by their preferred pronoun. Do you see any similarities there?
Yeah, I guess a little bit. I mean, we're talking more about freedom of expression with the flag issue as opposed to religious consciousness, if you will. I mean, both are First Amendment rights that are at play there. But specifically with regard to what's happening with these teachers, it's going to be interesting as to whether or not, to flip the script of what you just said a moment ago, they either force teachers or they put in a policy. What if they put into a policy? Students will be referred to by their biological, sex as to whether or not that's going to be an issue. So again, as I always say, Stephanie, when you're lawyering things through, I always say, would I rather be on this side or the other side? If there came down to a policy that said our school has a biological gender reference with regard to you, and you should know that in advance, I'd rather be arguing on behalf of the person that has freedom of religion and conscience than I would on the side that the school does not have a right, if you will, I know it's confusing, does not have a right to tell students that they're going to be called by their biological pronouns. So in favor of the professors on that one.
Yeah, well, it's a little confusing. It's kind of a mess. And then you think about those students who might consider themselves gender fluid. That is, like, one day they're female, the next day they are male, or they're not going by any of that. So it'd be a lot for a professor to keep track of. So again, very complicated and kind of a little bit of a slippery slope. Well, Bob, we got to leave it here. We appreciate you breaking down this case. Thank you so much.
Thank you.